And this case is from a few years ago, but I think it provides some important lessons nonetheless. So, from Norfolk, Virginia, 2012. Cops allege Rite shooter accused victim of cutting in line. It's interesting because as I already explained, the reason the survivor of the gunfight went to his gun was not because somebody cut him in line. It's because he was pepper sprayed by that person. It's quite a different reason, isn't it? But that's why you can't trust media reports on anything, folks. Now, certainly nothing use of force law related. Reading the article here, police have arrested a man after a deadly shooting sparked by an argument over jumping ahead of the line at a Rite Aid in Norfolk Thursday afternoon. It happened at the Rite Aid, just after 2 p.m., just at the drugstore to pick up some medications, and one guy ends up dead and the other guy ends up criminally charged for the killing. Police arrested and charged Bernell Duval Ben of the 8100 block of Richfield Drive with murder and use of a firearm in the commission of a felony. He's being held without bond. Police said that Ramon Colorado, how about that? That's where I live, died from injuries sustained in the shooting. Police said calls came in about the two men who had gunshot wounds near the pharmacy counter inside the rear of the store. Authorities said this started when police said Ben, the survivor, was talking on a cell phone when Colorado approached the counter and stood in line behind another customer. That's when police said Ben then accused Colorado of jumping ahead in the line. The two then exchanged words, and police said Colorado pulled out some pepper spray and tagged Ben. Tagged. He sprayed him. Next, Ben took out a gun, approached Colorado, and fired. Colorado also pulled out a gun and returned fire before collapsing. I'll caution him, when we watch the video, it looks a bit different than this description. Both men suffered gunshot wounds, but Colorado was pronounced dead at the hospital. Ben was treated and is now in police custody. So that was 2012. The survivor gets charged with murder. And in 2015, those charges are dropped. Charges dropped against man accused in fatal Norfolk Rite Aid shooting. Charges against Bernell Ben, the man accused of killing another man inside a Norfolk Rite Aid in 2012, were dropped in court on Wednesday. Ben was originally charged with second-degree murder, but that charge was reduced to voluntary manslaughter in 2013, which frankly makes sense. I'll talk about that in a moment. He was also charged with discharging a firearm in a public building. So the legal defense of self-defense would apply to both of these charges. The Norfolk Commonwealth's attorney statement said they decided to drop the charges after 2 jury trials held in the case ended in mistrials. In each trial, the jury was unable to reach a unanimous verdict. Both juries indicated that the majority of jurors wanted to convict, but a unanimous decision is required for conviction. The Commonwealth Attorney's Office decided that a third trial would likely not produce a different outcome. So what are the legal burdens in this trial, folks? This shooter has been charged with second-degree murder, and he's, of course, going to argue self-defense. That's his legal defense. So once he meets the burden of production for self-defense, which generally is not that hard to do, the consequences are catastrophic if you can't meet your burden of production, because then you're not allowed to argue self-defense. And if you try to argue self-defense, it's inherently a defense of confession and avoidance, right? You're not saying, I didn't shoot that guy. It was somebody else. I have an alibi. You're saying, I did shoot him. I shot him. He's dead because of my shot. But I did it with the legal justification of self-defense. Well, if you don't meet your initial burden of production on the legal defense of self-defense, meaning more than zero evidence on each and every element of the legal defense of self-defense, well, then by definition, if one of the required elements of the defense is missing, you don't get the defense. And if you don't get the defense, the second half of your statement disappears. Yes, I shot him, but I did it in self-defense. All that's left is, yes, I shot him, period. And that's just a confession. So meeting that initial burden of production is what you need to do to get your legal argument of self-defense into court in the first place. But once you do that, and it's generally, for anything that really looks like it could potentially be self-defense, is not that hard. Once you meet your burden of production, then the entire burden on self-defense shifts to the state. The burden of persuasion, the second half of the burden of proof in a self-defense criminal trial, the burden of persuasion is on the state to persuade the jury on the issue of self-defense. Specifically, the state is obliged to disprove self-defense beyond a reasonable doubt. Now, they don't have to disprove the entirety of your claim of self-defense beyond a reasonable doubt. They have to disprove any one of the required elements beyond a reasonable doubt. Elements meaning innocence, imminence, proportionality, avoidance, and reasonableness. If they can knock out any one, again, if it's a required element of the legal defense of self-defense and a required element is missing, then from a strictly technical perspective, it cannot have been lawful self-defense. So that's the prosecutor's mission. When he goes into a self-defense case, he knows exactly what he has to do. He has to disprove beyond a reasonable doubt any one or more, but any one would be sufficient of the elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Now, this is Virginia. So Virginia has, the most, I say there's these 5 elements. There's up to 5. It's possible for one or more element to be legally waived. The most commonly waived element is avoidance. Avoidance has to do with whether or not you have a legal duty to retreat before you can use typically deadly force in self-defense. And there's only 11 states that are strictly duty to retreat states. In an otherwise lawful case of self-defense, you still have a legal duty to retreat before you can use deadly force in self-defense. 39 states are stand your ground states. And I count Virginia among the 39 stand your ground states. They are a little loosey-goosey on how easily you lose that privilege to stand your ground, however. Most states have quite strict criteria. Usually it's statutory. It'll say as long as you're in a place you have a right to be, as long as you're not engaged in unlawful activity, in otherwise lawful self-defense, you don't have a legal duty to retreat. Virginia's, of course, an old state. So a lot of their law comes from old common law. It's not necessarily as technically precise as it would be if they drafted a stand your ground statute today. But Virginia's position is you don't have any legal duty to retreat unless you contributed to the affray. Well, what's that mean? Because in most states, even if you could stand your ground, you could still lose stand your ground if your use of force was not otherwise lawful self-defense. Say, for example, you were the initial aggressor, the initial person to threaten or use physical force, unlawful physical force. Well, then you would lose self-defense because you've lost the element of innocence. Right? Self-defense is not intended to be a legal defense for the aggressor in the confrontation. But if you lost innocence because you were an aggressor, you can regain innocence if you withdraw from the confrontation and communicate your desire not to fight. Now, for the fight to happen, the other guy has to come after you since you're withdrawing, and he's effectively the initial aggressor in a second fight in which you have the privilege of self-defense. So even in most stand your ground states, if you are the initial aggressor, the first person to actually use or threaten force, you've basically reacquired the element of avoidance. You've reacquired a legal duty to retreat because you've lost self-defense unless you withdraw from the fight. But those states, what's required to lose the element of innocence is pretty well defined. It's being the first to threaten or use force. Virginia uses this phrase, contributing to the affray. And it's much more loosey-goosey. I mean, if you get in a verbal argument with someone and you're eyeballing each other from a couple feet away and you're yelling at each other, mean words, that sounds like contributing to the affray. It's not being the initial aggressor. You're not being the first to use or threaten force. Let's just presume they're not shouting threats of violence, right? They're just saying you're a jerk, you're a moron, you're a dummy. So you wouldn't qualify as an initial aggressor in the traditional sense. So you wouldn't lose innocence in most states. So you wouldn't reacquire a legal duty to retreat just for saying mean words. But you might in Virginia. Virginia might say, no, when you got into that escalating verbal argument, you were contributing to the affray, and then you do have a legal duty to retreat under Virginia law. So it's a little more sketchy. Almost any kind of disagreement, right? I mean, it depends on how loose you want to define contributing to the affray. Would not be enough to lose innocence and reacquire a legal duty to retreat in most states, but might in Virginia. So that's where we are. The prosecutor needs to overcome, Ben's claim of self-defense by disproving one of the elements of self-defense beyond a reasonable doubt.